Sorry. Hi, everyone. We'll get started shortly. We're just waiting for people to filter in. Okay, so it looks like people have started to filter in. So, hi, everyone, and thank you for coming out to our quality program briefing. My name is Michael. I use he, him pronouns. Before we get started, we just have some quick housekeeping to do. So, this event is recorded, but your cameras will remain off for the entire webinar. There will be an opportunity to ask questions at the end, and I encourage you to start putting your questions in the Q&A section. We'll try to get to as many as possible. With that, I'd like to take a moment for a land acknowledgement. So, we recognize that many of us are joining from different places in Canada today, and we will not be able to acknowledge all the Indigenous lands our participants are living on. That being said, I would like to acknowledge that the CCLA's office and the speakers for this event are in Toronto, which is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis people. In the spirit of reconciliation, we acknowledge the land that Indigenous peoples have lived on and taken care of since time immemorial. So we are honored to be able to work on this land. Uh, with that, I would like to introduce our Director of Equality, Harney Siblingam, who's just going to give a quick overview of our equality program updates. So, Harney, please take it away.
Thank you, Michael, and good afternoon, everyone. It's so lovely to have you all join us today. My name is Harni Sivalinga. My pronouns are she and her, and I am the director of the Equality Program at CCLA. So welcome and thank you for taking the time to join us this afternoon to hear about the work that we are doing in the Equality Program at CCLA. This is a wonderful opportunity for me to not only provide you with a brief overview of some of the key cases and advocacy issues in the equality program that we're working on currently, but to also thank you for your interest and supporting the important work we do around promoting and protecting the fundamental rights and freedoms of all of us in Canada through the courts, the legislatures, and public engagement. So for those of you who may be new to CCLA or the Equality Program, I will start with a brief overview of what work the Equality Program does before I turn it over to my colleague Aidan to provide an update on some of the important work CCLA is supporting to advance 2S LGBTQIA plus rights in Canada. And I want to take this moment to wish everyone a happy Pride, as June is Pride Month here in Canada and in many places around the world. The Equality Program is concerned with the promotion and protection of the rights of individuals and groups who face discrimination and whose rights to full equality have not been materialized. In particular, those who are from the most marginalized and vulnerable segments of our society. So this includes Indigenous people, Black and racialized people, and religious minorities, women and gender diverse individuals, 2S LGBTQIA plus communities, people with disabilities, immigrant, refugee, and newcomer communities, and people who are living in poverty, just to name a few. And we recognize that human rights and fundamental freedoms, to have any real meaning, they must be equally accessible to every person. And this means that in order to achieve substantive equality in its most expansive and truest sense, that we need to take into account structural, institutionalized, historical, as well as current systems, including the legal and political ones, that contribute to marginalizing and disadvantaging particular groups, and also recognize the power dynamics that shape those interactions. As you know, it is often the most marginalized and vulnerable members of our society who are the prime targets of those who seek to undermine human and civil rights and fundamental freedoms. In addition, people who have intersectional identities, so identify with multiple identity groups, face additional challenges and barriers towards achieving equality. In CCLA's work advocating in the courts and the legislatures, we seek to highlight these gaps in laws and policies. And in the quality program in particular, we aim to shed light on how such laws and policies impact marginalized and vulnerable populations. So there are many important and pressing equality issues that we are currently working on in the equality program. It's been a very busy year for us. This year, we've been busy defending and protecting rights and freedoms of marginalized and vulnerable individuals and groups right across Canada. But this afternoon, I'll be focusing on a couple of these cases that CCLA has taken a leadership role in advancing legal challenges in the courts and to provide you with some important updates. So first, I will provide an update on our legal challenges defending religious freedoms in Quebec through our challenge of Bill 21 and Quebec's prayer ban in schools. And then next, I'll provide an update on our work fighting against racial profiling in the landmark case that has reached the Supreme Court of Canada. And then I will share with you an update on our advocacy to protect rights and freedoms of unhoused people living in encampments with a focus on Ontario. So first, I would like to provide some updates on our work to defend rights of minority religious communities in Quebec through our challenge of Bill 21 and a prohibition of prayer spaces in schools that denies accommodation for religious practices for students and staff in Quebec schools. So first with Bill 21, as you may already know, the CCLA, along with the National Council of Canadian Muslims and an affected individual who was at the time a teacher candidate, launched a constitutional challenge to Bill 21 in Quebec in 2019. Bill 21 was passed 6 years ago in June 2019 by the government and prohibits certain public sector employees from wearing religious symbols in the workplace. So let's take a minute to think about what that means. That means that if you wear a religious symbol, you are excluded from having employment and opportunities in many public sectors, employment opportunities in Quebec. And to make matters worse, the Quebec government used the provision of the charter called the Notwithstanding Clause to try to override important charter rights such as religious freedoms and equality rights. So Bill 21 is a discriminatory piece of legislation that negatively impacts individuals based on their religious beliefs. And it is clear that this legislation has a disproportionate impact on specific religious minority groups, such as Muslim, Sikh, and Jewish communities. And since Bill 21 came into force, religious minorities have faced increased marginalization in Quebec. So that is why we are fighting against this discriminatory law in Quebec government's attempt to override fundamental rights and freedoms by steamrolling over their charter rights. So last year, the Quebec Court of Appeal released a painfully disappointing decision that failed to acknowledge the harms caused by Bill 21. And so we could not let this discriminatory and harmful law stand. So we sought permission from the Supreme Court of Canada to hear an appeal of that decision. And earlier this year, in January, the Supreme Court of Canada indicated that it will hear the appeal. And so Bill 21 is now headed to the Supreme Court of Canada, the highest court in Canada, where we will continue to argue that the invocation of the Notwithstanding Clause does not shield Bill 21 from constitutional scrutiny by the court. And we hope that the courts will find this law to be unconstitutional. So moving on, Bill 21 is not the only case that CCLA is currently actively pursuing to defend religious freedoms in Quebec. CCLA is also involved in launching a legal challenge to a discriminatory ban on prayers in Quebec public schools that target religious minority groups. So in April of 2023, the Minister of Education in Quebec issued a directive that prohibits overt prayers in public schools in Quebec. So this is a total ban on prayers in schools that disproportionately impacts minority religious communities and contravenes both the Quebec Charter of Rights of Freedom as well as the Canadian Charter of Rights and Freedom by denying students the ability to obtain accommodation for their religious practices. So while CCLA does not support coercive religious instructions in schools, we are also opposed to government actions that discriminate against religious minority groups by failing to accommodate for religious practices of students that would allow them to obtain education as well as practice their faith. CCLA, along with the National Council of Muslims, sought an injunction of the total ban on prayers in schools. And while the court found that the directive did have harms on students, the court also felt that there wasn't a sense of urgency that warranted injunctive relief due to the impending summer break. So we appealed that decision to the Quebec Court of Appeal, and unfortunately, the higher court agreed with the lower court's decision. However, CCLA is continuing to fight against this discriminatory ban that harms students in Quebec through a case, and the hearing will be date has been set for September. So meanwhile, as we continue these legal battles in the court on Bill 21 and the prayer ban in schools, the Quebec government continues to introduce more laws that inhibit and infringe on rights of minority and religious communities and newcomers. Recently, the Quebec government introduced two bills that further erode the rights of minority and newcomer communities in Quebec under the guise of secularism. The government introduced Bill 84, which makes changes to the Quebec Human Rights Act that would weaken human rights protections, and also introduces stringent requirements for newcomers in Quebec to adopt French language and culture. The government also introduced Bill 94, which expands many of the harmful provisions that were challenging in Bill 21 to even more education workers, and introduces more restrictions onto students, including students that are being homeschooled, students that are in private schools, as well as public schools, by codifying the prayer ban that we are challenging as a directive into law. So both Bill 84 and Bill 94 were introduced invoking the notwithstanding clauses of both the Quebec and the Canadian Charters of Rights and Freedom. So CCLA joined with a coalition of many Quebec organizations that have raised concerns about Bill 94 and 84. And we also submitted written submissions to the committee studying Bill 94, outlining our serious concerns about the rights infringements contained in that bill. So due to the summer break, that bill has not progressed further and it's in committee stages at the moment. But we do anticipate that in the fall, things will pick up a bit more with those bills. So moving on to the issue, another issue that CCLA has been working on, another case that we've been leading is a challenge to police powers to conduct suspicionless roadside stops that enable racial profiling of Black, Indigenous, and racialized people in Montreal. So CCLA played an active role in this landmark legal challenge of racial profiling. And in an impressive decision, the lower court declared that suspicionless police roadside stops were unconstitutional. The Quebec government appealed that decision to the Quebec Court of Appeal, and they lost. The Court of Appeal's judgment was a major victory for equality rights in Canada. The court recognized the harms caused by racial profiling and agreed with the lower court's decision that the broad powers to stop drivers on a suspicionless basis contributed towards racial profiling and was unconstitutional. So despite losing at both the lower court and the Court of Appeal, the Quebec government once again is appealing the decision to the Supreme Court of Canada, which has recently agreed to hear the case. So CCLA is ready to defend this fight against racial profiling to the Supreme Court of Canada and to argue that no driver anywhere in Canada should be subject to useless, abusive, and discriminatory stops on the basis of race. So in conclusion, I'm going to sum up my portion of this update by talking a little bit about the equality program work that has been active in engaging to defend the rights of unhoused people who are among the most vulnerable members of our society. We have been involved in several legal cases concerning the rights of unhoused people who have been forced by municipal governments to leave encampments when they have no other place to go and no shelter options. We have also raised concerns about provincial measures that expand police powers to enforce evictions in encampments that would result in increased fines and even jail time for people living in encampments, such as the so-called Safer Municipalities Act in Ontario. This law does not actually make communities safer, but only seeks to push unhoused people further into the margins of society. CCLA has been advocating for a human rights-based solution to addressing the multiple crises of affordability, homelessness, mental health, and addiction that we know are plaguing many of our communities. In the interest of time, I will not expand more on some of these issues and encourage you to sign up to our newsletter and follow this area of work on our website. I will now hand it over to Aidan Pearson, who is our staff lawyer and trans rights legal fellow, who will speak about some of our work around promoting and protecting 2S LGBTQIA plus rights here in Canada.
Okay, thank you, Harney. Like Harney said, my name is Aidan. I'm the Trans Rights Legal Fellow and a staff lawyer who works with Harney in CCLA's Equality Program. I'm going to talk about a few cases that we've been involved in the 2S LGBTQIA plus sphere, and why these cases are so important to everyone and not just members of that community, and why having resources to do the work we do is really important, not just for the queer community, but for everybody. Um, but I think I'm going to contextualize the moment we're in by highlighting what's going on globally. And like I'm sure all of you know, the pendulum is swinging backwards in terms of public opinion on issues like race, gender, migrant rights, queer rights, and this is due to the rise of what we would call like the anti-rights movement or anti-rights ideology. So what do we mean when we say anti-rights? Um, Generally, like when people say that, it refers to political or cultural movements that attempt to undermine or roll back established human rights, and particularly rights that protect marginalized or vulnerable groups. But rather than framing this movement as anti-rights and seeming overtly oppressive, um, often anti-rights rhetoric disguises itself under slogans like freedom or parental rights, while systematically working to erode protections for marginalized groups like the ones that I've already mentioned. This is not new, though we're seeing obviously a rise of it again currently. But there are moments of it historically, and often they have kind of similar key features. One of which is the selective framing of rights. So um, uh, certain rights are promoted, usually for dominant or majority groups, while denying or restricting rights for others. So an example of this would be using freedom of religion, for example, as a reason to deny services to us LGBTQIA plus people. Another key feature is often there is an element of moral panic or scapegoating. So it plays on exploiting fear, falsely portraying something like gender diversity or anti-racism as threats. So to children, to families, or even more broadly to something like national identity. But at its core, anti-rights ideology seeks to reassert power hierarchies by pushing back against the hard-won social justice gains. And the result often is, and what we're seeing, is the rollback of protections for already marginalized groups, like reproductive rights, trans healthcare access, or inclusive education. So let's look at how this has manifested in Canada. Specifically, I'm going to focus on the sphere of 2S LGBTQIA plus people and the work CCLA is doing to fight back against that. So I'll start with what we call the parental rights cases. So, in recent years, the phrase parental rights, which you might have heard, has been repurposed, often by anti rights groups, to mean things like requiring parental consent before students can be called by a chosen name or pronoun, restricting access to gender affirming care for trans youth, or undermining school environments that that were affirming for queer students. In these cases, parental rights are invoked to justify overriding a minor's autonomy or a minor's privacy and safety. The framing really appeals to fear, suggesting schools or society are hiding things from parents, when in reality, these measures can expose vulnerable students to harm at home or cut them off from affirming environments. But how has this manifested in different parts of Canada? The first example of this that we saw very explicitly was in New Brunswick. Originally in 2020, there was a policy introduced, Policy 713, which was actually meant to ensure that queer students felt safe, respected, and included in schools in New Brunswick. It allowed students to be referred to by their chosen name and pronouns, even if they hadn't come out to their families. However, in 2023, the government changed and the New Brunswick government revised Policy 713. The changes that were made then required students under 16, I believe, to get parental consent before school staff could use their chosen name and pronouns. This was framed as a parental rights issue, but in practice, it ended up forcing schools to out vulnerable students or ignore their identities entirely. So in response, the CCLA, along with legal advocates, community advocates in New Brunswick that were on the ground working with students, we launched a lawsuit arguing that the policy revisions violated the Charter of Rights and Freedoms, and ultimately seeking to get them declared unconstitutional and, of course, repealed. But in December 2024, New Brunswick they elected a new government. And then in December 2024, Policy 713 was revised again to allow students under 16 to use their chosen name and pronouns in school without parental consent. Because this was really the goal of our lawsuit, we dropped the lawsuit earlier this year and consider this to be a win for rights protections. But the harmful impacts, I think, are notable because I think often we hear about like names and pronouns and they can seem like relatively minor to the outside community. But in the 1 year that this policy, the restrictive policy, was in place, the percentage of students who openly identified as queer dropped significantly on surveys. So, and these are largely the same students who 1 year prior had ID'd as openly queer. So there is definitely negative effects. Moving over to Western Canada, in Saskatchewan, the debate over parental rights has resulted in the enactment of what's called the Parents' Bill of Rights, which came in October 2023. This legislation mandates that students under 16 must obtain parental consent to have their chosen name and pronouns recognized by school staff, very similar. So EGAL Canada, along with the UR Pride Center for Sexuality and Gender Diversity, which is a center out of the University of Regina, they filed a lawsuit arguing that the legislation violates the Charter of Rights and Freedoms, specifically violates the protections around liberty, security, and equality. And when this lawsuit was brought, an injunction was also sought. And a Saskatchewan court granted an injunction against the policy, which basically says that until such time as the issues were determined by the court and the litigation had concluded, to see if this legislation violated the students' charter rights or not, the law would not be in effect. However, in response, the Saskatchewan government introduced the Parents' Bill of Rights, which allowed this policy to pass into law and have force of law by invoking the notwithstanding clause to shield it from being challenged on the basis that this legislation violates our charter rights. As Harini kind of already talked about, the notwithstanding clause allows governments to override rights and freedoms, so the law will go into effect notwithstanding that the specific law may violate your charter rights. CCLA is intervening in that case, meaning we're not a party, but we are involved in the litigation to make the argument that all legislation, whether the notwithstanding clause has been invoked or not, should be subject at least to constitutional scrutiny by the courts. As of right now, the Parents' Bill of Rights remains in effect with ongoing legal proceedings challenging it constitutionally. Finally, but certainly not least, we'll move over to Alberta. In October 2024, Alberta introduced 3 bills that were all passed into law very quickly. The first one is what's called the Fairness and Safety in Sports Act. This restricts participation in female sports only to individuals assigned female at birth, and requires that the athlete show their birth record, not birth certificate, to prove that they were assigned female at birth. It applies both to adult and minors, as well as to recreational sports like horseshoe throwing, darts, and every normal sport that you can think of, as well as competitive sports. Secondly, they passed the Education Amendment Act, which does essentially what Saskatchewan and New Brunswick did, restricts the use of chosen name and pronouns in schools without parental consent. But it goes farther in that it also creates an opt-in system for courses on gender identity, sexual orientation, or human sexuality and gender, instead of an opt-out system. And finally, any teacher that wants to teach materials based on those subjects has to get their resources and their teaching plans approved by the Minister of Education. So this law has not gone into effect yet, but it will go into effect in September of this year to coincide with back to school. And then finally, Alberta passed the Health Statutes Amendment Act. This is a novel restriction, at least from a Canadian perspective, on trans rights, which largely mirrors what we are seeing in the States. So it prohibits those under 18 from accessing puberty blockers or hormone therapy to treat gender dysphoria. It also bans gender-affirming surgeries like chest surgery. So these legislative changes have prompted a couple of legal challenges. Egal Canada, once again, has challenged the Health Act, along with groups that are working with youth on the ground, again, citing violations of charter rights, including the right to security of the person and equality. The Canadian Medical Association has also filed a constitutional challenge against the Health Act, which represents the doctors. I'm going to switch gears a little bit away from the parental rights cases and talk about cases, two other issues, if you will. The first is a case that CCLA was involved in here in Ontario, and it has to do with gender-affirming healthcare. The case is called KS and Ontario. It's a landmark legal decision concerning access to gender-affirming healthcare for trans and non-binary individuals living in Ontario. The details of the case are very legally nuanced, but basically, KS is a trans feminine person and was seeking a gender-affirming surgery. OHIP, which is Ontario's medical insurer, does cover gender-affirming surgery, or at least certain surgeries, but they denied KS because the type of technique she wanted to use was different than usual. But it was what was medically recommended by her doctor, and the surgery she wanted performed was also listed as a surgery that OHIP covers. So KS challenged the denial decision, and this case ended up going through 3 levels of court. It went all the way up to the Ontario Court of Appeal, and she won at every level. CCLA intervened in this case to highlight the need and right to equitable healthcare access for all, regardless of gender identity or expression. The Ontario Court of Appeal decided that KS was entitled to have her gender-affirming care covered and highlighted the importance of individualized approaches to gender-affirming care, which is exactly what WPATH, which is the World Professional Association for Transgender Health, recommends. It's what doctors are trained in. And the case also sets a precedent for interpreting healthcare coverage in a manner that respects gender diversity and diverse gender identities and expressions, and recognizing that healthcare should also mirror that. Finally, I'll talk a little bit about, so of course, I think, again, I'm sure all of our viewers have heard about recent immigration and refugee issues that are happening mainly in the States, but like everywhere. Obviously, it affects other jurisdictions as well. So CCLA has been monitoring the erosion of asylum seekers' rights in the US amidst growing concern around the measures being taken. Um, the measures that we're seeing being taken target both refugees, migrants, as well as gender diverse and trans folks. And some of the issues are separate, but a lot of them end up tangling together to impact one another. We have mainly been working around advocacy dealing with the Safe Third Country Agreement. And so that we're all on the same page, what is the Safe Third Country Agreement? It requires refugee claimants or asylum seekers, people who are looking to find a safe country, who are trying to escape violence and persecution in their home countries. Um, it requires them to make a refugee application in the first safe country they arrive in. The only countries that are designated safe under this agreement are the US and Canada. So if a refugee enters the US first, they cannot then apply for asylum in Canada, and also vice versa. There are some very limited exceptions, like if you're a minor who's not accompanied by an adult, but most of the exceptions wouldn't apply to a regular applicant. Um, However, with harsh new US immigration measures that we've been seeing, many are arguing that Canada should suspend or withdraw from the Safe Third Country Agreement because the US is no longer or should no longer be considered a safe country for refugees. Alarming recent measures around refugees that we've seen are increased deportations, expanded and expedited removal powers, interior detention within the states itself, boosted ICE agent numbers who are imposing criminal penalties for undocumented presence, as well as expanding ICE enforcement, including to areas like schools, hospitals, and places of worship. And there's also been a halt on refugee resettlement processing as well as asylum claim processing. So where this leaves us is with tens of thousands of pre-approved refugees for the states who now face indefinite limbo or forced return to unsafe conditions often without access to court review. And while this is also happening, there's also targeting of trans and gender diverse folks. So some harmful policies that we've seen are blocking passports. The US has been blocking passports that have had a sex designation change either previously or somebody who is seeking to do that currently. Federally, we've seen and on a statewide basis have seen a lot of anti-trans laws which do things like prohibit trans healthcare, prohibit trans folks from participating in recreation. And as well, there has been a new directive that has been tried to be blocked by the courts, but so far it doesn't seem to be being listened to, where housing trans inmates, trans inmates are being housed according to birth assigned sex, including those who are being detained at the border for trying to cross. They're being detained in like sex specific detention centers and it's determined based on your sex assigned at birth. So the consequences I think that we're seeing of this and how it's playing out is that gender affirming documents or recognition is not so trans people are being denied accurate passports and ID, which leaves folks without ID that reflects maybe how they externally present or just who they are. It's also created a huge amount of precarity for queer and trans refugees. There's many displaced queer and trans people who are now stranded in unsafe conditions. Trans asylum seekers have reported widespread gender-based violence, especially within the detention centers, as well as widespread sexual assaults, especially those who are waiting along the southern border region. And also the kind of ad hoc camps and shelters that have been set up are quickly running out of funding and money. So resettlement abroad is really their only path to escape violence from their country of origin. But now, without access to safe asylum, the risks of harm and persecution are ongoing, really. There is not really a safe place for them. And Canada and Mexico are becoming alternate escape routes. So continuing to enforce the Safe Third Country Agreement is risking returning people to harm. It's also, debatably violating Canada's obligations under international refugee law. So CCLA has been participating in advocacy around the Safe Third Country Agreement, including giving workshops and talks. We have a petition that you can sign urging the government to suspend the agreement or invoke exceptions to help protect refugee claimants who are at heightened risk of being targeted within the states, such as trans individuals or those fleeing gender-based violence. So you might hear, I've just talked a lot, and you might hear these developments and think, why should this really matter to me? Maybe you're not part of the queer community, and that's fine. Human rights don't exist in silos. When one group's rights are rolled back, the door opens for others to follow. And it matters because a society that targets the vulnerable is a society where no one is really safe. When the rights of any marginalized group, like trans people, are stripped away, it undermines the universal principle that human rights belong to everyone. And if protections can be removed from one group, they can be removed from others. And history shows that movements that want to centralize power within an executive often target vulnerable groups first as a way to concentrate power, silence dissent, or weaken democratic norms. And allowing or promoting anti-trans policies legitimizes and normalizes prejudice as well as state-sanctioned exclusion. This sets a precedent where governments feel empowered to target other communities. This could be racial minorities, disabled people, immigrants, women, religious minorities, and use very similar justifications that we're seeing being used to target trans people right now. So ultimately, it's about the kind of country we want to be, right? One where children can grow up, where no one has to hide who they are to feel safe at school, at work, or in public, where we have equitable access to healthcare services, excuse me, and where people are able to make choices for themselves about what's best for them, and our privacy is respected and free of state surveillance. And having strong allies, of course, is necessary for this work to be done. And like our donors directly contribute so that this work can be done and allows us to fight for this. So maybe I will stop talking and open up the floor to questions or to give Michael a second to say a few words.
So thank you so much, Aiden and Harney. Yes, so we'll get into questions briefly. Some questions have already been posted in the Q&A. I encourage you to go to the Q&A section and ask your questions. Before we get started on questions, however, I just wanted, for Pride, we've had these lovely stickers printed, and we've got a lot of them printed. So if you want, we're happy to send anybody who wants an envelope of stickers. So when you're celebrating Pride, you can have these stickers. If you want to email us at info@ccla.org, info@ccla.org, just let us know you want some stickers. We'll be happy, and your address. We'll be happy to send them to you. So with that, we'll get started on the questions. So the first question I have is for Harani, um, and it's asking, thanks for all your work. Thank you. Regarding the Quebec secularism cases, what is CCLA's legal argument for preventing the Charter's notwithstanding clause from shielding these laws and executive actions?
Thank you so much for that question. So we argue that the invocation of the notwithstanding clause does not shield Bill 21 from constitutional scrutiny by the court. So how do we do this? We actually argue, we have two arguments. So the first is that Bill 21 violates what's called the constitutional architecture, or like the structure of the Constitution, by limiting participation, public participation in public institutions. So what this means is that, like, if you think of it like a house, like the Constitution, like a house, there are pillars, right? So these are legal principles that structure and hold up the Constitution. And the Constitution is a written document. And so the written text of the Constitution needs to be informed by and give life to it, right? The Constitution is being called a living tree for a reason. So there are principles and doctrines that support and supplement the written text of the Constitution. And so we argue here that it is a principle of democracy and respect for minority rights that extends beyond just the rights which are important, enshrined, and guaranteed in the Charter, because they are also part of the very structure of the Canadian Constitution. And that is through like something like the principle of the doctrine of public participation in institutions. And so there are written rules in the Constitution that must be protected, which are one of the pillars of our democratic and inclusive society. The second argument that we put forward is that Bill 21 is what's called ultra vires, or beyond the jurisdiction of the province. So this is that classic like federalism argument that these are powers that the province doesn't have, powers to regulate and pass laws on, that because I won't bore you with all the details, but because um, the government, the provincial government, is trying to regulate um, morality by by um, by determining or trying to shape Quebec public society with certain religious or non-religious values in this case, that is delves into criminal law powers. So we've argued that that's beyond the scope of the provincial government. Um, and yeah, so that the province was attempting to regulate morality or fundamental social values, and that Bill 21 would impose prohibitive provisions that punish with penalties, which are recognized as an objective of the criminal law powers, which are within the domain of the federal government. And so it's the federal parliament, not the provincial legislature, which actually ultimately has residual jurisdiction over those, like that division of power between what the federal government and what the provincial government, by the Constitution, are allowed to pass laws and enact. I hope that wasn't too technical, but also gave you enough information, and I'm happy to discuss any of that further.
Perfect. Thank you, Hardy. So second question is for Aiden. And there's also a follow-up question to this as well. It's why do you think so many provinces are starting to roll back protections for trans youth after having more progressive policies for years?
Yeah, the rollback of protections for trans youth in many Canadian provinces, despite previously progressive policies, I think can be traced to a mix of political, cultural, and strategic shifts. I think politically and culturally, their right-leaning provincial governments are increasingly using issues related to gender identity in schools as political wedge issues, if you will. These debates energize certain voting blocs, especially those influenced by social conservatism or populist kind of anti-established sentiment. Um, this is the same thing we're seeing playing out on a federal level in the States right now, as I was kind of talking about. And some of this is the US culture war bleeding into Canada, but it plays on sentiment that already existed here. And trans rights, particularly youth rights, have become a proxy battleground in the broader kind of parental rights or free speech narratives. And this is dangerous because while Canada has human rights protections for gender identity, they are unevenly enforced. So provinces control education and healthcare, for example, and rights can be rolled back at the provincial level more easily, I think, than people realize, which is really like why, especially like in times like this, we need robust ability to bring legal challenge, because if the legislatures are going to treat rights as optional, then we need to rely in part on the courts to check that executive power.
Okay. And are teachers and education workers allies in protecting rights for trans youth?
Yes, I mean, of course, right? Like often a teacher-student relationship can be the safest adult relationship a student has, which I think is reflected too in how education workers and their unions have often been among the first to speak out against restrictive rules imposed by governments imposing anti-trans measures.
Thank you, Aiden. So the next question is for Harani. You mentioned the landmark racial profiling case from Quebec that's going to the Supreme Court. So if CCLA wins this case there, what does that mean? Does that mean racial profiling is illegal everywhere in Canada?
Yeah, so it does, even though the court case stemmed from Quebec and it dealt with Quebec provincial laws and policies, because the case has gotten up to the Supreme Court of Canada, and if the Supreme Court of Canada does, we hope, rule that police power that is in the common law, and that the law, like, or that the government is relying on, is unconstitutional, that would apply to throughout Canada. So even as it stands right now, the Quebec Court of Appeal case does set a precedent. That's why we call it a landmark decision that declared that the police powers to stop someone without suspicion in roadside stop is unconstitutional, is landmark, and it does translate to other jurisdictions. But it would just be, if there was a court case, they would have to, each court would have to look at, it wouldn't have as carry as much weight as a Supreme Court of Canada decision, which is binding on the other courts. So they would have to follow it. So this would be something that is applicable throughout Canada. Now, the corollary of that is that even though the law says something's unconstitutional, there's also a practice and a culture that we also need to change. So just because the law changes doesn't mean or sorry, not the law changes, but it does apply to that too. But just because there's a court decision that says that something is unconstitutional, it doesn't necessarily follow that materially things change on the ground. So I do think it's really important for local police forces, local governments, provincial government to ensure that racial profiling and the police powers that enable racial profiling are actually stopped and don't continue. And I think that's where the real work and challenge lies, is ensuring that what the court decision eventually, hopefully, says, if it does rule that way, will actually materialize in on the ground in reality.
Thank you, Harani. So next question is going back to Aiden. What is happening in the U.S. around trans and LGBTQIA plus rights is really alarming. How can we try to ensure this level of anti-rights discourse and exclusion doesn't happen in Canada?
Yeah, great question. It is very alarming. Um, I mean, I think the rise in disinformation, particularly online, tends to fuel panic and backlash. So championing things like evidence-based education about gender identity and sexual orientation in schools, and educating and encouraging critical media consumption skills, like whether it's teaching that to young people or encouraging whoever, like older folks in your life or peers, um, to kind of get smart about what we're reading and what's true, to kind of counteract these, what is almost like kind of becoming like viral falsehoods, is very important, to ensuring that we have like we don't tend in the same, as far down the same road as the states have. Um, and I guess what I'll also say is like human rights codes already prohibit discrimination based on gender identity and expression, but uh, they're not always enforced. So legal advocacy, court challenges, and accessible complaint processes are essential to defending these rights, like actually in practice. And supporting organizations that are doing that work to protect rights. Like CCLA is one, but there is also Egal Canada. There's Skipping Stone in Alberta. They're doing really great work to help protect rights. That's another way that we can like kind of try and reverse this trend. But also, I guess we're doing a lot of work around like advocating around the liberal use of what we would call the liberal use of the notwithstanding clause, which allows governments to override rights. So I guess like paying attention to how these things are being used by our governments and what they are being used to override. I think so in short, I mean, it takes a coordinated effort across, civil society, government, law, education, and culture, which is a huge ask, but it is really what is necessary. And I think the window to really act to try and reverse the trend is now, before more Canadian politicians continue to test the water with these kind of like copycat US style policies.
Thank you, Aiden. And we have another question related to that, so I'll come back to that. I just wanted to ask this question first for Harani. Is there any more information on Bill C6 regarding unhoused people living in encampments within Ontario?
Yeah, so Bill C6 has passed, and so despite local organizers and advocates raising the alarm bells, including the CCLA, who wrote a letter to the Premier of Ontario urging them not to withdraw the bill and urging MPPs to vote against it, it did pass, and it also passed alarmingly without consultation with communities that are affected and experts who are knowledgeable about what are the solutions that could actually meaningful address the very real issues around the housing crisis, homelessness, and addictions that are plaguing some of our communities. So it did pass, and right now it's on. There are a lot of it is enforced, and so we are working with community groups to monitor what's happening in how it's being that law is being enforced and implemented. And there are community-based organizations that are exploring legal options to challenge Bill 6 in the courts. And CCLA is monitoring and involved in those discussions. And we will see what transpires on the legal advocacy route. And in the meantime, we are just continuing to raise concerns and alarms about the impact and monitoring what's happening through our connections with local organizations that are on the ground.
Thank you, Harney. So Aiden, coming back to the issues surrounding trans youth, this question is asking, I'm very concerned about these issues and protecting rights for trans youth and everyone who identifies as part of the 2S LGBTQIA plus A communities. What can I do to support the work CCLA is doing in partnership with members of these communities?
Yeah, I mean, so financial support is always like the one obvious answer. It's always appreciated. It goes towards helping us do the rights work that we do. Um, you can also, if you're a legal practitioner or a lawyer, always like feel free to reach out to us. We're always looking to partner with lawyers to help us advance these things because we do have limited resources. Um, and then, you know, maybe Harney, you can like jump into if you have anything else to add, but um you don't have to work directly with CCLA too, right? Like these issues are widespread. Like I was talking about, these issues also impact like refugee and immigration, that sphere, healthcare, like equality rights. Like these things like intersect with a bunch of different spheres. And so if you are someone who is like particularly passionate about a certain area, see like what you can do. Like there are tons of community groups that you can get involved in and provide like whatever skill set that you have to help these issues. I don't know, Harney, if you have anything else to add.
Yeah, I'll just add, like, in addition to what Aiden has already outlined, I think it's really about, like, if you want to make a difference in, mobilizing and changing, you know, changing the narrative, I think it's really important just having conversations with people. Just, talk to your neighbors, your coworkers, if you have children, your kids, friends, parents, and just, have those conversations with people about why some of these issues matter, how they impact the groups that are affected. I think those are how we actually change people's minds and win them over about why these issues are important and why they should be concerned. So, it's really sharing the information that you learned here. If you learned something, hopefully you learned something new here today. And if you did, sharing that with people in your life and having those dinner conversations and, just engaging, right? Like one of the things that CCLA really fosters is critical thinking, engaging in debates, even if you may not agree with people. At the end, just having those conversations is very eye-opening, and it, fosters this sense of, discourse and robust, respectful discourse. Like we don't always have to agree on things, but it's really important to have this vigorous conversations and debates. And I think that's really the way to affect social change and to advance rights and freedoms is by talking to each other. So that's the only thing I would just add is you don't have to think big picture of I want to change, I want to impact this case, or I need to be a lawyer, or I need to, be a teacher to impact all these changes. You can do that in your own everyday life by having these conversations with people that are in your lives, with your neighbors, with strangers even, right? Engaging in respectful conversations that talk about the importance and the impact of all of these rights infringements on communities and why you care about these issues, sharing that with people in your lives.
Thank you, Hardy. So this is going to be our last question. We have about 3 minutes left on this. So, and Hardy, this actually isn't related strictly to the equality program, but it's important. So hopefully you can answer it just briefly. So this question is asking, I saw on the news that CCLA is starting litigation about the new bubble zone bylaws, which are being enacted by many Ontario communities. Can you just talk briefly about what these new laws are and why we're concerned about them?
Yeah, so what Michael's referring to are what are called bubble zone bylaws, which are laws that they take various different shapes and forms. And what they do is they restrict protests within a certain distance from certain sites. So the case that CCLA announced yesterday is challenging bond bylaws, which are very intrusive, and they are the most severe that we've seen to date, which have widespread limitations on the right to protest, the right to peaceful assembly, and the right freedom of expression, because they restrict what they call nuisance protests from from a wide sector of healthcare, hospital, and daycare centers. One of the things that's really interesting is this would, like Vaughan City Hall itself has a daycare, so this would prohibit protests at this very site of the City Hall, which is very deeply problematic because, one of the constitutional rights that we have is to peacefully protest, and that's something that CCLA has been vigorously defending for over 60 years now. So this bylaw and our challenge to it is an important way to stand up for everyone's right to protest and to have free speech and to peacefully assemble.
Perfect. Thank you so much, Hardy and Aiden. That was a fantastic presentation, fantastic Q&As. So we're going to wrap it up here now. So just a reminder, this was recorded. We'll be sending you an email with recording in around a week or so. We will be hosting another one of these in a couple months, so please keep an eye on our emails. We'd like to see you out again. And if you do want the stickers, you can email me at info@ccla.org, so info@ccla.org, and we'll be happy to send you an envelope with stickers. So thank you. Hopefully we see you again in a couple of months. Have a great summer, and see you later. Thank you for coming out.